Hi! We assume you're watching this video because you are thinking about how to get into home ownership or back into home ownership, and conventional financing may not be an option for you. I'm Linda Cook, and this is my colleague Joe Maskovyak. We're both attorneys with the Ohio Poverty Law Center, and we want to talk to you today about some alternative pathways to home ownership, give you an overview of some options, and give you some ideas to think about when you're making this decision.
Before we get started, we need to warn you about foreclosure rescue scams. In this video, we are not talking about ways you can save your home from foreclosure. If you are in default on your mortgage or already in foreclosure, and you are contacted by anyone who claims they can get you out of foreclosure and help you keep your house by having you deed them the property, turn around and run the other way as fast as you can. Chances are, offers like these are scams. You will lose your money and still lose your home.
Okay, let's get back to the subject at hand. First, there are good reasons to consider ways other than conventional loans to buy real property. For example, you believe you would not qualify for a loan from a conventional lender.
Or you don't have the money for a down payment.
Or you have damaged credit, and these options could help you build your credit.
You have some personal or family finance arrangements that are appealing. However, before we talk specifics, here are some cautions that apply to all of these choices. Before you agree to any deal, read the contract carefully. Approach these agreements just like you would if you were going through a conventional home purchase. In Ohio, all contracts concerning the sale of land must be in writing to be enforceable. If the person you are dealing with does not give you a written contract that includes all of the terms of the agreement, remember my advice from before. Run away, just like you would run away from a foreclosure rescue scam.
Right, Joe. And do your homework. Check out the seller as much as you can to make sure he or she is honest. Inspect the property thoroughly yourself and pay a trained home inspector if you can afford to. Make sure you understand what your responsibilities will be under the agreement. Do a title search to make sure the seller will be able to convey clear title.
You have probably heard of some of these terms before. First, lease with an option to purchase. 2, a lease purchase or rent purchase. And 3, land contracts. There are other more exotic possibilities, but these are the most common. The first two choices have some similarities. Land contracts, or to use the exact legal term, land installment contracts, are different creatures. We will talk about those separately.
With a lease purchase option or a lease purchase agreement, you start the transaction as the tenant with the goal of becoming the owner of the property. Because you are a tenant, the responsibility for repairs and maintenance remains with the landlord. Legally, the landlord cannot shift this responsibility to you. Up front, you and the landlord agree what the sale price will be at the end of the lease period. Up front, you pay the landlord a fee for the option of buying the house at the end of the lease period. This is not a security deposit, and usually this fee is not refundable for any reason.
You pay monthly rent for the period of the lease, typically 1 to 5 years. The rent covers the monthly outstanding mortgage payment the seller has on the property, and you may pay an additional amount that will go into an escrow account to later be applied to the closing costs or the selling price. At the end of the lease, if you follow through with the purchase, you must seek financing to pay the seller the agreed purchase price. If you fail to follow through with the purchase, all bets are off with the seller, and you are back to being merely a tenant. Be aware that failing to follow through with the purchase may give your landlord cause to ask you to leave and cause to evict you if you do not leave.
So, here are a couple of questions to ask yourself if you are considering a lease purchase. Will you qualify for a mortgage later? Be honest. Ask yourself if your circumstances are really going to change enough in the next 1 to 5 years so you will be able to get conventional financing.
Is the cost worth it? The option fee rarely counts toward the eventual purchase. If you do not follow through with the purchase at the end, will you lose some or all of the escrowed money in addition to the option fee?
Now, let's talk about land installment contracts. These are different because, unlike lease purchase deals, land installment contracts are covered by an Ohio statute, Chapter 5313 of the Ohio Revised Code. Under a land installment contract, you are not a tenant. You are a buyer who builds up equity in the property over the life of the contract. Instead of paying a bank, you are paying the seller who is acting as your lender. Unlike the lease option choices, you assume the responsibilities of ownership, including maintenance and repair. There are numerous requirements for land installment contracts under Ohio law, too many to easily list here. On this website is a presentation that lays out all of the requirements necessary for land installment contracts under Ohio law. We strongly recommend you review that information before entering into a land installment agreement.
Before you enter into a land installment contract, you should understand that if you stop paying on the contract, the ease with which the seller can take back the property depends on how long you have lived in the property or how much money you have paid. If you default before you have paid at least 20% of the principal, or if you have lived in the property for less than 5 years, the seller can use the expedited process of eviction to take the property back. However, if you have paid more than 20% of the principal or lived on the property longer than 5 years, the seller will have to use the longer court process of foreclosure to remove you in the event that you default. In both cases, if you lose the court case, you will lose your down payment plus all the money you have paid toward the purchase. You will lose all of the equity you have built up. In addition, if you have made improvements, you will have to go to court and argue whether you are entitled to be paid by the seller for the value of those improvements.
Bottom line, as with all important choices, gather as much information as possible. Ask questions until you are satisfied that you understand the deal. Be realistic about your finances and keep good records.